Hello, how you doing?
Hello.
Hello. Hold it back up. I'm holding it back. I ain't do nothing to it. It went off itself.
If one needs to mute their screens,
I don't see anything on my screen. How many people joined? They put you on mute, so put it back on here. You know what I'm saying?
That was my fault. Good afternoon, everyone.
Good afternoon, Your Honor.
I was just waiting in the wrong Zoom. So I am finally in the right one. So I apologize for being a little late here. Okay. Ooh, let's see.
What's your plan?
Go ahead and get started. Ladies and gentlemen, good afternoon. My name is Regina Mincy, and we are going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this is usually the defendant's initial appearance before state court judge, so we will address several matters, including bond, possible arraignment, and consideration of any possible plea offers if one has been made by the state at this juncture. I'll also be providing you with a reset date for arraignment if it is not held today. So I'm going to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. And I want to remind those persons on the calendar that you have a right to remain silent, that anything that you state about the facts or occurrences and circumstances regarding your case can and will be used against you. You also have a right to an attorney to represent you today. So you'll see your attorney on this Zoom screen as well. And you need to govern yourselves accordingly and defer to your attorneys and do what they ask you to so that they can represent you and you will not make any statements against your interests. So be careful with that. All right, where are we starting first at Courtroom 2?
Position 9. Your Honor, the state would request a breakout for position 9, and position 15 has related facts. So for the breakout, I would ask that ASG Falk and ASG Shatika Duncan also join so that both cases could be discussed.
Yes, because I have position 15, he's next.
Okay, let us go on a breakout real quick, Deputy, and we'll come back to you.
And Your Honor, I would like to be included in that breakout session as well.
Oh, I think you did. You left out Ms. Gant. I'm sorry.
It's,
Anybody else with you, Ms. Gant?
It's PD Chem.
Kim?
Judge Missy, would you want to do both of them together?
Yeah, probably so, or at least back to back. Don't see PD Kim on the screen yet. There we go. Okay, and we'll put you in the breakout as well. Let us discuss these cases, and then we'll be right back.
Judge, you're muted. You're on mute.
Thank you. I am sorry. We're back on the record with position, who do you have there? 9 and, you've got them both, 9 and 15.
9 and 15, yes, Judge.
All right, the first case, position 9 is 22 CR 000-367J. Mr., is it Andarico Holloway?
Yes, ma'am.
All right, and the second case is 22 CR 000-372G, which is Jerryon Matthews.
Yes, ma'am.
All right, you both have one count, and for indulgence of the court, I will not read what that one count is. With an offense date of January 26, January 26. I may say PI, leave it at that. And each of you has a $10,000 surety bond. No drugs, alcohol, or weapons while on bond. And there is another condition in there that you will be told about with no further contact. So that is what the ruling of the court is. And in abundance of caution, we were able to discuss it with all sides involved in the chat. Okay. And so that will conclude the matter with each of you.
Next judge will be position
All right, so
20. Ms. White. Ms. White.
And the burglary. Do all intake. She's on that too. I'll tell you about the intake.
Okay.
No, she's been on you.
She's right here, Judge.
Okay.
You have to pay attention.
All right. Is it Shermaya or Shemaya? Not sure how to pronounce the first name. Watley. This is case number 22 CR 00376D. There is one count of disorderly conduct. Second count is simple assault. Third account, obstruction of a law enforcement officer. Fourth count, possession and use of drug-related objects, all with the offense date of January 26, 2022. Ms. Duncan, or let me say this, pre-trial, I'm sorry. Do you have anything?
14 total. Last was 2020. FTAs for obstruction, possession of drug-related objects. 2019, that's when she was arrested for the original charges. What else? Another 2019 possession of drug-related objects. 2014 driving without a valid license. 2014 obstruction and PI conviction. She had an obstruction from 2013 that was NOD'd. 2011 probation violation for forgery not prosecuted was a disposition. 2011 misdemeanor possession of marijuana and one of those public order crimes. And a 07 battery family violence arrest.
All right. Let me say this too before you start, Ms. Duncan. On the other two positions, 15 and number 9, the reset court date is February the 10th. And I don't think I said that. February the 10th on both of those, 15 and number 9.
Thank you, Your Honor.
All right. Go ahead, Ms. Duncan, on position, excuse me, position 20.
This incident occurred yesterday, Your Honor, at the Marta Hamilton E. Holmes train station. The accused in this case was sleeping on the train that was going westbound. She was encountered by Officer D. Pfeiffer and was told that they would have to get off the train and pay the fare because it was the last stop to be able to ride back. And once apprised of that information, the defendant decided that they did not appreciate that order of the officer, and they began to scream and curse at the officer so loudly that it caused a disturbance, causing other patrons to exit the train and to try to see what was going on. And then when they reached the elevator, the defendant in this case threatened the officer and said that she would beat her ass and that she should punch her in the face. She took a fighting stance and clenched her fist and lunged at the officer several times before being escorted off of the property. Due to the violent nature and the facts as stated, there's a recommended bond on this case of $3,500 total. That's $1,000 for the disorderly conduct, $500 for the simple assault, $1,000 for the obstruction, and $1,000 for the possession and use of drug-related objects. And in this case, not only after she left the train, she was exited from the building, but she did have drug-related objects, and I believe it was a glass pipe. So for those reasons, and the history is pretty I stated, we're concerned that she has a flight risk due to her recent FTA, and she does have a previous obstruction conviction. So we request that the bond remain as recommended at the $3,500 total, a stay away from all MARTA, no further contact with the victim in this case, no alcohol, drugs, or weapons, and a one-day anger awareness.
Okay. Ms. Gant, this is yours.
Yes, Your Honor. Thank you, Miss. Shermaya Watley is 32 years old. She was born and raised in Atlanta, therefore she has community ties. She completed high school. However, she has been unemployed for 1 year. She will not be able to pay anything toward bond, Your Honor. Therefore, I am requesting a signature bond on Ms. Watley's behalf. According to my research, Your Honor, in November of 2019 and July of 2019, there were possession and willful obstruction of law enforcement charges, but those were null prost. What we have here is a conviction in 2014, and that is nearly almost 10 years ago. Ms. Watley understands the importance of following up and complying with legal process. Therefore, Your Honor, I am confident that she is committed to coming back to defend against these allegations. She denies these allegations. At this time, we're unopposed to the stay away order. We're unopposed to no further contact. And again, we would request the signature bond or a low bond. Thank you.
All right, I'm going to order a surety bond in the amount of, let's see, for the first charge, disorderly conduct, $1,000, simple assault, $500, obstruction, $500, and possession and use of drug-related objects, $500. So that's $2,500. $2,500. So that surety bond would be $2,500. No drugs, alcohol, or weapons while on bond. No further contact with D. Pfeiffer, and a stay away from all MARTA train stations. And I think that's it. If you are to make bond, Ms. Watley, you're not to use MARTA, not to be on any or in any of the MARTA train stations. So you'll have to use other transportation methods if you make bond. Okay? And that should conclude this matter.
Thank you, Your Honor.
Thank you, Your Honor.
Position 3, Colford.
Jamarco Cofer.
Yes, Your Honor.
This is case number 22 CR 000-362Y. You're charged with 1 count of battery family violence and 1 count of simple battery family violence with the offense date of January the 12th, 2002. You have anything pre-trial?
The 7th adult arrest. Last arrest was 2020. Failure to appear for trafficking heroin. Possession of dangerous drugs, 2 counts. FTAs for obstruction, counterfeit substances. He got first offender. Got a 2018 probation violation for burglary, gang participation. 2017 sale of counterfeit substances. Possession of a Schedule 1 or 2 controlled substance. Felony obstruction. 2016 probation violation, burglary in the first. Came off a 2013 conviction, first offender. 2013 battery family violence, it was dismissed. His first 2 cycles of juvie history. That's it.
Okay. All right, Ms. Arnold?
Yes, good afternoon, Your Honor.
Mm,
The state is recommending a $3,000 surety bond for count 1 for the battery family violence and a $2,500 surety bond for count 2 for the simple battery family violence for a total of a $5,500 surety bond. We're also recommending a stay away from 2637 Cascade Road, apartment 4 in Atlanta, that there be no further contact with Latanya Barnett, Latanya spelled Latonya, Barnett spelled Barnett, a 1-day anger awareness course, and no drugs, alcohol, or weapons. Your Honor, this incident happened on January 12th, 2022 at that Cascade Road location. Ms. Barnett advised that the defendant went through her phone while she was asleep and saw a text from someone else. I wasn't clear who that was, Your Honor, but after which the defendant struck Ms. Barnett in the face. He then followed up by picking Ms. Barnett up by her neck and throwing her onto the bed. Officers made note in the warrant that Ms. Barnett had visible bruises on the right side of her neck. Your Honor, we are requesting this bond because we do believe that the defendant will reoffend based on his history. He has a probation violation from 2016. In addition, he has the 2013 burglary conviction in the first degree under first offender, as well as an additional probation violation in 2018. And then he had an arrest out of DeKalb in I'm sorry, Your Honor, I misspoke. That probation violation was from 2018. He also has a 2013 battery family violence that he was arrested for, but that was dismissed. Your Honor, we were able to speak with the victim in this case. She stated that they do have 2 children together, ages 4 and 6, but they do not live together. She stated that she does fear the defendant and does not want any contact with him. She did state that the violence has occurred before between the 2 of them, but she has been trying to just have a healthy co-parenting relationship with the defendant. However, Your Honor, based upon the history and the fact that the victim has said this violence has occurred before, we are requesting the $5,500 surety bond with the conditions as stated. Thank you.
all right, Ms. St. Flux?
Yes, Your Honor. Mr. Cofer, we have no issues with no further contact if that's what the alleged victim is requesting. He has lived in Georgia his entire life, so he does have ties to the community. I did not hear any violent convictions. I heard drug-related convictions. And furthermore, the conviction of the burglary that was stated to be under first offender is not a conviction if it's under first offender. And so we would just be asking for a signature bond because Mr. Cofer does not, he's not employed right now. He hasn't been employed the last 2 weeks because he lost his job. If the court is not in a position to grant a signature bond, we would just ask the court to consider a $1,000 good bond. As far as the address that was listed, we had a different address, but he does have ties to the community, so he would be able to go to a different address.
Your Honor, if I may, the victim did mention that she would be on Zoom today, so if you would like to sound for her.
Yes, Miss Latanya Barnett, are you on the Zoom, Miss Barnett? I see a few iPhones with no names. Anyone here on the case with Jamarco Cofer? Let's see. No, I saw movement. That's why I thought maybe that was her. All right, no, Miss Barnett. All right, we will go forward.
And Your Honor, I did forget to mention one thing that I just wanted to mention for the court. It appears that this charge has the same time period for both the simple battery family violence and the battery family violence. So we would argue that this is the same transaction in occurrence, even though the prosecution has separated it into two different charges. And so we would just ask the court to consider that when issuing the bond, because it's our position that this shouldn't be two separate incidents as the way it's listed, but it should just be one charge.
What is the state's response to that, Ms. Arnold?
Yes, Your Honor, the state would just argue that although these did happen on the same day, they were two separate offenses. One where he first slapped her in the face when he woke her up. And then at some point later during that altercation where he dragged her, where he picked her up by the neck and threw her onto the bed.
Okay. Well, I'll leave them as two actions and charges at this point. And then y'all can just kind of go from there as the case moves along. What I'm going to do regarding bond today, I'm going to give a surety bond on the battery family violence, $2,000, on the simple battery family violence, $1,500. So that'll be a total of $3,500. No drugs, alcohol, or weapons while on bond. Also, a stay away from the 2637 Cascade Road, Apartment 4. And no further contact with the victim, Latoya Barnett. And I think that is everything. No drugs, alcohol, or weapons while on bond.
Your Honor, we would ask for a one-time escort to with an officer to get whatever remainder items he has at the location.
All right, and I will add to that, Ms. Middlebrooks, one-time law enforcement escort to the property to retrieve his personal belongings. So, Mr. Cofer, you're not to go back to that location unless you have law enforcement with you to escort you to be able to arrange to get your personal belongings.
Yes, Your Honor.
All right, thank you. That will conclude this case.
Position 4, Coleman.
All right, are you Edwin Coleman? Can you hear me?
Good afternoon, Your Honor.
Okay, good. You're Mr. Edwin Coleman.
That's correct.
All right, this is case number 22 CR 0003638. You're charged with 1 count of battery family violence with the offense date of 12/23/2021. Anything pre-trial?
19 total. I counted about 5 failure to appears. He don't have any violence. Leave it at that.
All right.
Oh, his last arrest was 2020 for DUI.
All right, Ms. Arnold.
Yes, Your Honor. The state is requesting a $3,000 surety bond for the battery family violence. We're asking for no further contact with Monique Henson. Stay away from 24 Ollie Street, Ollie spelled Ollie, Northwest in Atlanta. Drug alcohol drug evaluation and treatment, 1-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident occurred on December 3rd of 2021 at that Ollie Street location. Ms. Hinton advised that her husband, the defendant in this case, was high on cocaine when he punched her on the right side of her face while they were lying in bed. Ms. Hinton stated that after the defendant ran out of the front door and left in his vehicle, when officers arrived on the scene, they were able to observe Ms. Hinton's face was red, swollen, and puffy. We do believe that the defendant we do believe that the defendant is a flight risk, Your Honor. As pretrial stated, he does have 5 FTAs, one from 99, 2000, 2008, 2016, and 2017. Your Honor, we are also requesting that ADET because we do have concerns. He has a 2015 conviction for DUI, driving under the influence of alcohol, and then arrest in 2018 for 2 counts of DUI, alcohol, a 2013 arrest for DUI, alcohol, and then a 2020 arrest for DUI, alcohol, Your Honor. We were able to speak with the victim in this case, Ms. Henson, and she advised that she and the defendant have been married for 8 years. She stated that she does not fear the defendant, but that she does know that he's been stressed out due to his losing his job and has started drinking, which is what resulted in this incident. She did state that they have not had any violence in their relationship before. However, we are very concerned if there is an issue, Your Honor, which again is why we're requesting that ADET, and we want to make sure that we can keep Ms. Henson safe. So we do respect her wishes, but we would still be requesting no further contact, Your Honor, and the stay away. So for these reasons, we are requesting that $3,000 surety with the conditions as stated. Thank you.
All right, Mrs. McLeod, how are you? I can't hear you. No, still can't hear you. It doesn't look like you're muted either.
I'm not muted.
There we go. Okay, let's see. Well, you went back out on me. I got 2 words.
Yes, as the prosecution has pointed out, Your Honor, my client does not have any violent history. Most of the history that he has is traffic-related offenses. He has been married to the alleged victim for 8 years, and the prosecution did state that she has said that she's not afraid of him, and there has not been any previous violent contact between them. My client tells me that they were drinking, and his wife she was standing over him, trying to get his phone, and he hit her by, he was flailing his hands and he hit her, that it was not intentional. He did not know. He was arrested on a warrant. He did not know that there was anything, he did leave the home. He came back the following day and they continued to live together, and he was unaware that there was a warrant pending for his arrest concerning this matter. He tells me that he has had a business. He's lived in the Atlanta area all his life, so he does have ties to the community. He tells me that he had a business doing home renovation work, but that business, he's not been very successful at it recently because of COVID. Your Honor, I do believe that the defendant is a good candidate for a signature bond, even though that he has had previous failure to appear. I think on this particular incident that he will appear, because he has expressed that he's concerned for his marriage and for the relationship. He had no intent to harm his wife, and she herself is not afraid of him. So for those reasons, Your Honor, I would request that he be given a signature bond, because he has told me that he doesn't really have any money to bond himself out of jail. Thank you, Your Honor.
All right, thank you.
Your Honor, if I may respond.
Yeah.
Your Honor, I would just like to put on the record that we do respectfully reject Ms. McLeod's version of the facts that the defendant was just flailing about and accidentally hit his wife. The police report says that officers were able to observe that Ms. Henson's face was red, swollen, and puffy, Your Honor. So that would not be the result of just the accidental flailing about, Your Honor. So we would just like to put that on the record and make note of what the warrant did say. Thank you, Your Honor.
Okay.
And I'm here, his wife.
Okay. That's what I was going to say. Do we have anyone here on this case? And your name is, ma'am?
Yes, Your Honor. My name is Monique Henson. I am Edwin Coleman's wife. We have been married about 8 years now.
Can you raise your right hand for me?
Yes, ma'am.
Do you affirm that the testimony that you're about to give is going to be the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. And so tell me regarding this incident and after it happened, are you afraid of Mr. Coleman or fearful of him coming home?
I'm not fearful of him at all, of coming home. And the version of the incident is actually that Mr. Coleman, prior to this incident, had began drinking heavily due to, I believe, depression of not working, sitting around the house, drinking excessively, staying up late at night due to insomnia. This particular night, that's what occurred as well. Mr. Coleman, I asked him several times to please just put his phone down. The light is shining in my eyes and I'm trying to sleep so that I could work. Mr. Coleman was mumbling, not making much sense, I believe due to being heavily intoxicated, not really understanding what I am trying to ask. At that point, I did jump up and try to grab his phone. And at another point, I did throw a shoe on his phone. This is when Mr. Coleman hit me. Mr. Coleman claims that he thought I was going to throw the shoe at him or hit him. However, the aim, my target was simply the phone. That is how the incident did begin. He ran out of the door and I called the police. He does not have any prior violence. He returned back here 2 days after the incident, apologizing, and has since curbed his drinking and began working slowly but surely, but he has not received a paycheck as of yet. We've had no prior violent incidents and we don't foresee having any future violent incidents. He's also been speaking with his mother more concerning prayer and getting some help for his depression. And so I do not fear him and we rely upon each other a lot. We're married. So I would like to ask that he can return home. And I'm not opposed to, I think she mentioned treatment or something. I think any treatment for someone that may have a problem would be excellent or great. And that is all I ask. I also ask if he can just please be released by his own signature. Some of those failure to appears are not intentional. I can attest to this. I've been with him 8 years. Some of those he actually went and did reschedules where they did not advise him they were denied. And that is why he had failure to appears.
Okay. All right. Miss McLeod, did I miss or forget? Did you tell me about Mr. Coleman as far as employment or little work history?
I did, yes, Your Honor. He told me that prior to the COVID, that he had a business renovating homes, but that the COVID, it's pretty much died because of the pandemic.
All right. I'm going to do a $3,000 surety bond. No drugs, alcohol, or weapons while on bond. I'm going to as far as that 24 Ollie Court, that is the marital home, Ms. Henson, with you and Mr. Coleman.
Yes, ma'am, it's Ollie Street, and that is the marital home for both of us. Yes, ma'am.
Okay, as far as Mr. Coleman going to a different location or address, will he have somewhere to stay?
He does not, the 2 days that he was gone, he was sleeping in his vehicle. He does not have any other place to go. He also has slowly regained about 2 clients, one who contacted him today for work. And so he also needs to be available. I also assist him with getting clients for his home renovation as it basically died out, but I am trying to help him revive it. I also sold my car, I'm sorry to mention, because my daughter wrecked my car totally. And I also now rely on Mr. Coleman for transportation purposes at this moment until I purchase another vehicle.
I'm gonna order no further violent contact with you, Ms. Henson, but I'm torn a little bit on the stay away. I want to make sure there's been ample opportunities and cool down for these type of incidents to not happen anymore.
Yes, ma'am. This was in December that this occurred. I know, and we have talked thoroughly. Again, we have been speaking with his mother, praying. We're trying to just work more on, working together and communicating. And he understands the importance of not drinking heavily and sitting around being depressed. That's not gonna help anything. And so he has really pretty much stopped drinking altogether, as he understands that's how he got into this issue. And it can cause future incidents as well if you're angry when you're drinking.
I don't know what the state's position is, but I'm going to not order to stay away from the marital home at this time, but no further violent contact with you, Ms. Henson. And
Thank
so,
you.
Mr. Coleman, if you do return home, you're not to get into any altercations, physical or verbal, with your wife, Ms. Coleman, or else you can be arrested again. So I will order the 3,000 surety bond, no drugs, alcohol, or weapons while on bond, and no further violent contact with you. I'm also going to order the ADEA evaluation, and if it recommends treatment, then he will follow that course of treatment for the ADEA too. All right.
Thank you, Your Honor.
Thank you.
All right.
Your Honor?
This matter.
Your Honor,
Yes.
just out of curiosity,
Hold on.
Hold on. And I hope it's a general question, because if not, Ms. McLeod is going to cut you off.
What's the bond amount?
The bond amount is $3,000.
That's good.
is that good
Yes.
enough? Will the bond company pick that up, or is it too low?
No, they'll pick it up.
Okay, that's my question.
Mhm.
Okay, thank you.
All right.
Position 8, Greer. Hey,
All right, you're Mr. Rodriguez Greer.
Yes, ma'am.
This is case number 22 CR 0000366A. The charge of 1 count of simple assault, family violence with the offense date of June 20th, 2020. Do you have anything pre-trial?
25 total. Last arrest was 2018 for fighting and disorderly conduct. 2012 June, they gave him 1 year to serve, 9 years probation for burglary. I think I counted about 10 probation violations in the system. That's about it.
Okay. All right, Ms. Arnold.
Yes, Your Honor, the state, the current bond is set at $1,000 surety. The state is recommending that that bond remain. We are also asking for no further contact with Teresa Greer. Teresa spelled Teresa. Greer spelled Grier. We're also asking for a stay away from 1349 Kenilworth. Kenilworth spelled Kenilworth Drive in Atlanta. No drugs, alcohol, or weapons. Your Honor, this incident happened on June 20th, 2020. Ms. Teresa Greer advised that her son, the defendant, threw a lawn chair at her after they got into a dispute about him talking loud and cussing on the phone. Your Honor, we are concerned that the defendant will be a flight risk based on the fact that he has FTAs from 2000 and 2003. In addition, we are concerned that he will reoffend based on the fact that he has several probation violations, as pretrial has stated. He also has the 28 conviction for 2 counts of violation of a city ordinance, as well as the 2009 and 2012 burglary convictions, Your Honor. So for these reasons, we are requesting that the bond remain with the conditions as stated. Your Honor, we did try to reach out to the victim, but we're not able to. However, we did leave a message for her. Thank you, Your Honor.
All right, this is Ms. St. Clair.
Yes, Your Honor. I spoke with Ms. Greer this morning. This charge is, as stated, a few months shy of being almost 2 years old. Ms. Greer said in the last 2 years, she and her son has been having contact. This is her son, and that she hasn't had any issues with him. There hasn't been any follow-up charges, and that they've still been living together. And so we would ask that the stay away is not ordered. I asked her if she would be fine with contact. She does want contact with her son. She's an older woman who receives assistance from him. I asked her if he gets violent with her, and she stated that she finds that sometimes he'll get loud or she finds disrespectful, but she does not have any fear of violence against her. Mr. Greer does have ties to the community, as he's pretty much lived here his entire life. His grandma stays next door to his mother. So he's back and forth at both of their houses, and they're all 3 of them are pretty close. In addition, Your Honor, I think there was mention of him being a flight risk from charges that was over a decade ago. And so based on the history, I think the charges that were mentioned, the FTAs that were mentioned, were a drastic amount of time ago, over 10 years. And so I do not believe he's a flight risk. Additionally, the 2018 was the earliest before this charge that he had a charge. And from my understanding, he hasn't had an issue since then. So we would just ask the court grant a signature bond, because he is in a financial position where he's probably not going to be able to afford the $1,000. His mom is not going to be able to afford the $1,000. She asked me if I could ask for a signature bond. I did try to Zoom her in, but she has a very old phone that she said doesn't have video. All she can do is call and text. So she wasn't able to Zoom in this morning. And so for those reasons, Your Honor, we would just ask that our signature bond request is granted.
Okay.
Your Honor, if I may respond.
Yes.
Your Honor, we would just like to point out to the court that this incident happened or began because the defendant was talking loud and cussing on the phone, which resulted in him throwing the chair at his mother. And the defense has said that there has not been any more chairs thrown specifically, but that there is still arguments or loud talking in the home, which seems to be the reason that we're here today. So that's still ongoing, Your Honor. So we would just like you to consider what defense has said when making your ruling. Thank you.
Okay. All right, for the 1 count of simple assault, I will, I think you said the bond right now is $1,000 surety bond.
Yes, Your Honor.
I will make it an $850 surety bond.
Your Honor, respectfully, we would just ask that it stay 1,000. If it's under 1,000, then the bond company will make people pay the cash. If the court is not inclined to do signature, rather than it being $850, we would just prefer it stay at 1,000.
All right, thank you for that information, Ms. St. Flex, and I'll just leave it at the $1,000 surety bond. And then, of course, there's no further contact with Ms. Greer. And I don't know, is there already a stay away from Kenilworth or not? I don't really want to change the bond, any other conditions that are on there.
Let me take a look, Your Honor.
Okay, I know no drugs, alcohol, or weapons while on bond.
Your Honor, I am not seeing a current stay away in place.
Yeah, but he can just come up.
Okay,
Just stand up right there, young man. Come on, just stand up.
well, I'll just leave the no further contact with the victim, Teresa Greer. I won't order stay away at this time.
Okay, thank you, Your Honor.
Mhm.
Next is position 10, Judge.
10, okay. Are you Mr. Corey Jones?
Yes.
All right, this is case number 22 CR 000-369F. You're charged with 1 count of battery, family violence, and 1 count of cruelty to children in 3rd degree. The offense date of January 25th, 2022. Do you have anything pre-trial?
His 4th arrest. Last arrest was in 1998. So suspended license, and that was dismissed. He had a 96 battery first offender. And a 96 simple battery first offender. That's it.
All right. Oh, Mr. Long, yes. Go ahead.
Yes, Your Honor, thank you. The state's recommendation for bond in this case is $3,000 surety, no further contact with Tanjar Jones, that's TANJAR. Stay away from the marital home of 7519 Springbox Drive in Fairburn. We have no objection to him returning one time with law enforcement to retrieve property, 1-day anger awareness, no objection to a third-party transfer for their minor children in common, no drugs, alcohol, or weapons. The charges stem from the victim calling the police after she had returned home from a vacation. And when she returned home, the defendant in this case demanded her phone. She refused to give him the phone, and a tussle ensued over the phone. The defendant then choked Mrs. Jones and pushed her to the ground. Mrs. Jones got up and she tried to leave with her daughter, who had witnessed the event. But Mr. Jones tried to pull their daughter back, stating that she wasn't going anywhere without shoes. Mrs. Jones was able to eventually get her daughter and leave. Law enforcement noted that Mrs. Jones had minor bruises on the side of her neck. The state has had contact with Mrs. Jones, and I do believe she's on the Zoom. I'm not sure if she wants to speak today. Based on our contact with her, she indicated that they are married. They have 2 children. She is in fear of the defendant, but she does need to have contact for the children. So she was okay with the one-time law enforcement escort for him to retrieve his things. She also wanted the third-party contact set up. She importantly did not want to discuss the details of the incident with us in great depth, especially when we were asking about strangulation. So we are concerned about the potential risk for intimidation in this case. She is clearly in fear of the defendant, but won't go into more specifics. Moreover, factually, the behavior by the defendant that's exhibited as evidenced in the warrant appears to be highly controlling in nature, with him attempting to grab her phone and prevent her from initially leaving with her daughter as well. We do also have a concern about reoffending, understanding that the history for the battery priors is older. But given the facts of this case, where there's an alleged choking with visible bruises on Mrs. Jones's neck, we do not feel that the prior history should be discounted. And for those reasons, we are asking for the $3,000 surety. Thank you.
And is that what, 1,500 on each? What's the breakdown?
Yes, $1,500 on each.
Okay. All right. Ms. Flex.
Yes, Your Honor. Mr. Jones and the alleged victim have been married for over 6 years. It's my understanding, and based on the criminal history that we heard, that this is the first violent incident between them. I know that the prosecution stated that the history shouldn't be discounted, but it's something that's used when it's recent or when it's a lot of history. So I think it should be considered when it's over 20 years ago in 96 and 98 for charges that were pled under first offender that are no longer convictions. And so at this point, we don't have any criminal convictions of any violent charges against Mr. Jones. And so we would just ask the court to consider that. Mr. Jones did graduate from college. He has a bachelor's in information technology with a concentration in cyber security. As far as intimidation of the witness, Mr. Jones understand if right now Ms. Jones does not want to have communication. I've explained that to him, and he has an address here that he can go to. He does have sisters, brothers, and aunts who live here, so he does have ties to the community. Additionally, Your Honor, he was working at the Atlanta Public School in the IT department as a student advisor specialist before he was arrested. I also think it's important to note out, I think the prosecution may have been reading from the police report, but based on the warrant that was submitted for our review, the warrant says that Mr. Jones did intentionally batter by choking and pushing to the ground. Nowhere in the warrant did it allege any visible injuries to the side of the neck, as was stated this morning. Additionally, the accusation that was filed said that Mr. Jones grabbed her, causing visible injury. But again, the accusation didn't state any visible injury. So it's our position that this really is a simple battery case, which can't even carry a cruelty to children within itself. And so we would just ask, based on the lack of history that Mr. Jones has, that he's given a signature bond this morning. If the court is not inclined to give a signature bond, we would ask for a $1,000 bond. If he's not able to go back to the residence, we would be asking for that one-time escort, as well as that he's able to, between a third party, interchange to see his 2 children.
All right, I'm going to order that there will be a surety bond And with that surety bond, it will be in the amount of $2,000, $1,500 on the battery, $500 on the cruelty. I'm going to order at this time no further contact with Ms. Tandra Jones. Ms. Jones, do you wish to address the court? I see you on the screen.
Yes.
Asked that before I gave my ruling. I will hold on that. You do want to address the court?
Yes, I just would like to say
Hold on
that,
1 second. Hold on 1 second. I need you to turn on your camera. Can't talk to you if I can't see you.
okay, can you see me now? Sorry, my Girl Scout background, yes.
That's okay. And raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. All right. And put your hand down and go ahead and tell me, are you in fear of Mr. Jones returning or?
Yes, ma'am, I am. Even though he have not physically harmed me before this incident, he still has an intimidation factor about him that I am fearful of. Mr. Jones is an excellent father. However, the relationship between us has been rocky, and he has this intimidation factor about him that scares me.
Okay. All right. And that probably does answer my questions. I'm going to, I was starting to give my ruling, and what I would like to do is change a little bit after considering and talking with you. I'm going to leave it at the state's request for the $3,000, and I will do $2,000 on the battery and $1,000 on the cruelty, which will be a total of $3,000 surety bond. I'm going to order no further contact with you. It's at Tandra Jones.
Yes, ma'am.
I'm going to order stay away from 7519 Springbox Drive in Fairburn. I'm going to have a one-time law enforcement or police escort if Mr. Jones wants to return to that home to retrieve his personal items while on bond. Also, if there will be any visitation with the children, it must be done by third-party exchange, so that, again, Mr. Jones will not have any contact with you, Ms. Jones, while on bond. No drugs, alcohol, or weapons while on bond. And I think that suffices for everything. Is there anything else that I need to take up?
No, Your Honor, thank you.
All right, that should conclude this case.
Thank you.
You're welcome. Thank you.
Next is position 12, Kendrick.
All right, you're Antonio Kendrick.
Yes, ma'am.
All right, this is case number 22 CR 000-370B. You're charged with 1 count of battery family violence with the offense date of December the 25th, 2021. You have anything pre-trial?
8 total. Last was 2019 criminal damage to property, 2nd degree. It was amended to trespass, and that was dismissed. It was a simple battery with that arrest. I don't see the disposition on the GCIC for it. 2015 probation violation for burglary. Got a battery no low, battery family violence no low, giving false name, and trespass from 2014. 2013, he had battery family violence, battery simple battery that was dismissed. 2013 probation violation. 2011 loitering upon the school premises that was dismissed. That's it.
All right, Mr. Long.
Thank you, Your Honor. So in this case, the state's recommendation for the battery family violence charge is $6,000 surety. No further contact with Raven Mills, common spelling for both. Stay away from the victim's address. I do not know if the victim's address is the incident location of 370 Northside Drive, Northwest 2342. But wherever she does reside, we are asking for a stay away, 8-week anger management, no drugs, alcohol, or weapons. In this incident from Christmas, there was a domestic dispute call. Law enforcement met with Miss Mills. There was a visible swelling knot on the right side of her head and a broken nail. She said an argument occurred with the defendant, who punched her in the head with a closed fist and fled the scene. She also indicated that they live together and share a child in common. She told law enforcement that she did not want to press charges. However, despite her wishes, the state is highly concerned for Ms. Mills. We do think that the defendant has a high risk of reoffending based on the priors that pretrial had mentioned, specifically of particular interest, the family violence battery from 2013 that was null pros, the family violence battery obstruction and battery, which was no plea in 2014, and the 2019 case. I did contact Clayton County for the 2019 case, and they have indicated that the case is actually open, and they have filed an accusation there against the defendant with this same victim. The counts are battery, simple family violence, battery or simple battery, and criminal trespass for damaging property. That's still an open case, and I was able to confirm that with both the clerk and the solicitor's office in Clayton County. Because of that, we are highly concerned for Ms. Mills' safety, and we would ask that the court issue the $6,000 surety with conditions as stated.
All right, Ms. Kim. Oh, you're on mute.
Your Honor, I actually had a chance to interview the victim, who clearly said that she does not want to make she does not want to make any charges against him. She's not afraid. Indeed, they are engaged to marry this coming February 27th, and she's willing to move forward with that wedding because they also have one child who is 5-month-old, and they are actually he has a strong ties here in Atlanta, Georgia. He was born and raised here for the last 31 years, and he has 3 other children here. He's not a flight risk at all, and he does not have any failure to appear, even though he has an open case. He will come to the court, and his victim is not afraid of him actually, and they are willing to live together, and she's willing to talk to him. And he also mentioned that it's okay. We don't have any objection about the stay away order because he has another place to stay. However, no contact is not really encouraged because of the wedding, and also maybe they can do no violent contact. And however, the couple want to continue to keep in touch with each other. That's it, Your Honor.
Okay.
We request for a lower bond because of the fact that he is not employed at this point. He does not have a mean to pay for $6,000. So we request at maybe $1,000 low bond.
Okay. And looks like he's about 31 years old. All right, I'm going to order a $5,000 signature bond. I'm sorry, a $5,000 surety bond. I apologize, a surety bond. Good bond, and no further contact with Raven Mills. And I don't know if the state has any information or not, or if you do, Ms. Kim. I'll just go ahead and say stay away from 370 Northside Drive Northwest. We're assuming that is Ms. Mills' location. Also, no drugs, alcohol, or weapons while out on bond. And that again is a $5,000 surety bond with the stay away and no further contact. Anything else?
No, Your Honor.
All right. That will conclude this matter.
Position 1, Anderson. Okay.
And Your Honor, we requested a breakout for this position.
Okay. Mr. Jordan will get us there.
Judge, on them felony charges, he got no bond earlier, so.
Okay.
So who else going in the breakout room?
Myself, Shelley Falk,
And Arnold
Alexandria Arnold.
and Miss, is it St. Flax?
Yes, Your Honor.
And you want Miss Gant in there?
Yes, Your Honor.
Okay.
Didn't Gant have a breakout one too?
I thought it-
She has a breakout with her defendant, position 19, but
Oh, that's sorry. She.
Oh, that's fine.
Y'all discussing one or both?
no, she's in a separate breakout with the defendant,
okay.
position 19. We're doing a breakout on position 1, but if Ms. Gant's unavailable, I'm not sure how the court would like to proceed on that.
Okay, interesting.
Didn't mean chat meant breakout. Now, Ms. Gant, can you see is there's one in the chat for the South Annex? No?
Okay, let me check. I messaged Courtroom Two earlier because I did not see a specific link there.
Yeah, I don't either. I'm not for sure who.
She's there, but she's still doing felony also.
Oh,
still
she's doing felony also? Oh, they're juggling. Okay.
Yes. Where she is? Hold on, I'm gonna go back to it.
Someone
don't
is
see
not
it,
there.
Your Honor.
Who's iPhone? Please mute yourself. We'll let Mr. Jordan get a message to them.
I'm here. I'm here.
Who's that with iPhone?
Juanita Gearing.
And which case are you on?
Miss
Edward Gearing, Mom.
Okay.
Miss Gearing, you can mute and we'll let you know when to unmute, but you can stay muted for right now.
Okay.
We haven't gotten to that case yet. Okay, we'll see what Mr. Jordan is able to work out for us so that we can keep moving. And who do we have in Courtroom Two?
We still have position one.
Okay.
I just came out of breakout room with,
Right. Okay, and so I'm going to order that. So we have our surety bond of the 7,500, 5,000 on the first charge and 2,500 on the second. And I'm going to order the MHBT. No further contact with the victim. It's Interior Lyons. Did I see Miss Lyons on the Zoom?
That's how infant class Zoom me. That's how.
That's her? Okay. Miss Lyons, do you wish to address the court?
No, I don't.
Okay. All right. Thank you for your time. We're going to order the MHET as well and a stay away from that Budgetel Hotel.
Can she
4120 FIB.
All right.
Yeah. Go ahead.
I need y'all to stay away from me too.
Yeah,
Your Honor,
it works both ways.
Okay. That's cool.
And Your Honor, can you also note in there what we had spoken about for it to be sealed and sent to the defense?
Yes, and when that, Miss Middlebrooks, can you make sure with that report, once it is complete, that it should be sealed and sent to the defense? Is it?
Beaver.
Oh, she said the conflict defender, when they send it over, it does not state that? Oh, it does.
They would indicate that.
They usually have that in the order when they send it over, Ms. St. Flex. Are you aware of that?
I'm not sure, to be honest, Your Honor. I have seen it at times, but there have been a couple times where I haven't seen it. So out of
Right. And we want to make sure. Yeah, I agree with you. Note that for me, Ms. Middlebrooks, and we'll look on there to make sure that report is sealed and sent to the defense. All right, Ms. Middlebrook has that noted. All right. And that should conclude this case. You have the 7,500 surety bond on position one, deputy in courtroom two.
Yes, Judge, I do.
All right, thank you.
This is position two.
Okay.
Here he's conflict.
Oh, okay. Do we have our conflict defender on too?
Yes, Your Honor.
Ah, there you go. All right, Ms. McLeod. All right, this is the case of 22 CR 0000361G, Samuel Beaver. Are you Mr. Beaver?
Yes, ma'am.
Okay, you're being charged with 1 count of battery family violence. The offense date January 26, 2022. Do you have anything pre-trial?
14 total. History out of Maryland, Pennsylvania, Alabama, and New Jersey. Last arrest was on the 7th of this month for DUI. He's on probation and card for ag assault. Got a 2012 terrorist threats conviction out of Pennsylvania. Firearm carried without a license, 2012. Out of New Jersey, out of 03 simple assault. Out of Maryland, a 2010 assault 2nd degree, guilty. 2009 battery family violence out of Alabama. 2006 assault domestic violence that was dismissed out of Alabama. With that 2016 arrest, it was an ag assault, 2 counts, 3 counts actually. Simple battery conviction and simple battery family violence. 2014 probation violation. Got a battery he pled NOLO to battery family violence. In 2013 out of Gwinnett. That victim was Tivia Williams. That's it.
Okay. All right, Ms. Arnold.
Yes, Your Honor. The state is requesting a $5,000 surety bond for the battery family violence. No further contact with Michelle Jones. Michelle spelled Michelle, Jones spelled traditionally. A stay away from 3787 Martin Luther King Jr. Drive, Southwest, apartment A8 in Atlanta. 1 day anger awareness, no drugs, alcohol, or weapons. Your Honor, this incident happened yesterday at the MLK Drive location. Ms. Jones advised that she and the defendant were in a physical altercation. The defendant received a phone call from his child's mother, and shortly after that call became irate and agitated with Ms. Jones. Ms. Jones stated that she went to the bedroom to lay down, and the defendant followed her into the room, Your Honor. Then he jumped on top of her and began striking her in the face multiple times with a closed fist. Officers made note that Ms. Jones had visible injuries that placed her in physical danger of her life, and those injuries were captured on officer's body-worn camera. Ms. Jones was transported to Grady Hospital for her injuries from that location, Your Honor. We are concerned that the defendant will reoffend. You just heard pretrial go through his history. We are concerned. He does have the conviction from November 13th for the battery family violence where he did plead NOLO. He also has the 2016 conviction for 3 counts of aggravated assault and 2 counts of simple battery. He had a September 2010 arrest for battery family violence and a criminal trespass. He also had a 2016 arrest out of Cobb County for aggravated assault, terroristic threats and acts, and simple battery, Your Honor. And for these reasons, we do believe that he will reoffend. In addition, he had the 2014 probation violation as well. Your Honor, we have spoken with the victim, and she did state that they are in a relationship and live together, but that they do not have any children. She stated that she does fear the defendant. She has a black eye currently and a swollen lip. She stated that the defendant does have she believes he has a drinking problem and suffers from PTSD. She said that she does not want any contact with him and does not want the defendant to return back home. Your Honor, when you were ready, she did say that when you're ready to sound for her, she said that she would be here on the Zoom call. So for these reasons, Your Honor, based on the defendant's fear, as well as our concern that the defendant will reoffend, we are requesting that $5,000 surety bond with the conditions as stated. Thank you.
Miss Michelle Jones, are you on the Zoom call? Michelle Jones? Oh, I see you, Michelle Jones. Can you hear me, or do you want to?
Yes, Your Honor. I hear you. I didn't want to speak because I didn't want to be on video.
Okay, you don't? Okay. All right, I understand. We have the information, so I appreciate your time. All right, Ms. McLeod?
Yes, Your Honor. My client has told me that he suffers from time to time from seizures, and he says the incident that occurred yesterday, he doesn't have any memory of it because he had a seizure at the time. He tells me that he was taken to Grady Hospital by the police, and he has an appointment to go back on February 7th for them to evaluate him because of these seizures that he has had. He explained to me that the arrest that he had last week was that he had an accident because he had a seizure, and he realizes, Your Honor, that perhaps he should not be driving anymore. But it appears to me that he is quite ill, Your Honor, concerning with the seizures he's been having. He's 51 years old. He really isn't very young, and I would like the court to take that into consideration in setting a bond for him.
Okay. You know, Ms. McLeod, I'm going to get you to say 51 is not very young, is it, or is it not?
It is, relatively speaking, not very young, but I'm a lot older than that, Your Honor. So, and I don't feel old. Let me put that on the record.
Right. So anyway, I appreciate that. Let's see. I am going to, based on the evidence that I've heard today, I'm going to issue a surety bond, and I'm going to issue it in the amount of $4,000. And I'm going to order no drugs, alcohol, or weapons while on bond. I am going to order no further contact with Michelle Jones. I'm going to order stay away. I did not write the address, MLK A8. You have it, Ms. Middlebrook? Yeah. Okay. Stay away from that Martin Luther King location, apartment 88. And so, Mr. Beaver, you're not to go there, and you're not to be around Ms. Jones at all while on bond if you make bond. You understand that?
Yes, ma'am.
Okay. All right. That should conclude this matter.
Thank you, Your Honor.
Thank you.
Your Honor, this concludes my business before the court today. May I be excused?
Yes, you may. Thank you. All right.
Thank you.
Next judge is position 537, same person.
Oh, okay. 5 through 7. Gotcha. Are you Mr. Is it Eldridge? Is it Gearing or Gearing?
Gearing.
Gearing, okay. I have the first case of 22 CR 000364G. That is 1 count of battery family violence with the offense date of October the 13th, 2021. True child, do you have anything?
12 total. Last
Is it
was
12?
12.
Okay.
2020 probation violation. Underlying charges: false imprisonment, robbery, possession of marijuana. 2019 probation violation. 2017, same thing. 2016 FTAs for added assault with a deadly weapon. Two counts. 1 count FTA battery. 1 count FTA possession of a firearm during the commission. 2014 battery conviction. 2014 felony theft by receiving, misdemeanor possession of marijuana, not presented to grand jury. 2011 shoplifting. And he had an arrest out of Ohio, 2015 telecommunications fraud. That's it.
Okay. All right, Ms. Arnold.
Yes, Your Honor. In this case, the state is requesting a $3,500 surety bond for the battery family violence. We're also asking that there be no further contact with Adriana Napolitano. Adriana spelled Adrianna. Napolitano spelled Napolitano. Stay away from 903 Huff Road, apartment number 1313 in Atlanta. 1-day anger awareness and no drugs, alcohol, or weapons. Your Honor, this incident happened on October 13, 2021 at the Huff Road location. Ms. Napolitano advised that she and the defendant got into an argument over some socks that he wanted to wear. The defendant got so upset that he dragged Ms. Napolitano across the floor by her hair, causing a bruise on her left knee. When Ms. Napolitano called the police, the defendant left the location at that time. Your Honor, we do believe he will reoffend based upon his probation violations and his history. He had 3 probation violations in 2017, 2019, and 2020. In addition, he has an arrest out of Fulton for aggravated battery, 2 counts of aggravated assault with a deadly weapon, 2 counts of possession of a firearm during commission of a felony and a battery. He was not convicted on those charges, however, Your Honor, but he does have convictions from 2015 for robbery, false imprisonment, purchase, possession, manufacture, distribution, or sale of marijuana under first offender. And then he has a 2014 battery conviction, Your Honor. For these reasons, Your Honor, we do believe that he will reoffend, and he also poses to be a potential flight risk as he has the 2016 FTA. So for these reasons, Your Honor, we are requesting a $3,500 surety with the conditions as stated. Thank you.
All right, Ms. Sandflex.
Yes, Your Honor, we do not believe he is, and Mr. Gearing is a flight risk based on the last FTA that we have recorded is from 2016. He does live here in Atlanta, in the Atlanta area. And I'm sorry, not in Atlanta, but he has lived in Georgia his entire life. We will say the 903 Huff address, based on my conversation with my client, as well as his mother, is his address. So we would just ask that the court does not order a stay away. His name is on the lease. He lives there with another friend, and it's my understanding that the alleged victim in the case is someone who goes from state to state, from place to place, but she does not live at that address. And so if the court were to order a stay away, the court would essentially be ordering him to stay away from his own home. We would have no objection to a no further contact, however, which would do the same thing, not allow him to be around her. It's also my understanding, Your Honor, that he has 2 children, a 4-year-old and a 3-year-old that he supports through the job that he was working before this arrest at Exclusive Game ATL, where he was a sales associate for over 6 months. So for that, we would just ask that, considering that we're probably going to be ordering a bond on the other 2 cases, that his bond for this case is not $3,500, that it is a signature bond, or if the court is not inclined to give a signature bond, for $1,000 or $1,500 good bond. And Your Honor, I don't know which case, but probably I'll wait till the last case to have his mother, or she can do it now, verify that that address is in fact his address. She's on the Zoom call now. And that it's our understanding that on different occasions, the alleged victim went through the door to get to the alleged, to get to my client in these matters, and confronted him with a new girlfriend. And so we would just ask if there's any question or issue as to address for purposes of stay away, because we don't want him to be homeless and not able to return to his own address, that the court allow his mom to verify that that is in fact his address.
Okay. Is the mother of Mr. Gearing on the line?
Mom.
Mrs. Gearing, she's under iPhone.
Oh, is that the iPhone?
Yes, Your Honor.
Mrs. Gearing? Hello?
Yes, ma'am.
All right, can you turn on your camera for me?
Okay. Hold on. Video. The host asked you to start your video. Okay. Yes, ma'am.
Yes, how are you doing?
I'm okay.
Fine, tell me your first name.
Juanita Gearing.
Juanita Gearing. Can you raise your right? Would you like to address the court today? Okay.
Ma'am.
Yeah, would you like to address the court today?
Yes, ma'am.
Okay. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. And so tell me this, again, you're the mother for Eldridge Gearing?
Yes, ma'am.
All right, and does he reside with you?
He have mail here. You know, it's like that. He's not homeless. He always have a home to go to, but he was residing with a friend at what's that 903 Huff Street. But he do reside, you know, he do stay here too at 3560 Homeward Trail, where his mail and everything come. But you know, he have a roommate too on that 903 Huff Street.
Okay.
That's where he's been staying at.
Right, but then what's the and so do you know if the victim in this case, do you know her, Adriana Nala?
No, ma'am. I really don't know of her, but I heard a lot about her. I really don't know her.
Okay. And had you been told that she resides on Huff Road?
Ma'am?
Had you been told that she resides with your son on Huff Road?
They was, you know, I guess they was, what you call it, lovers or whatever, but you know, they parted and she left, and you know, he got another friend, you know, he got another female friend, and you know, they had been away from the house by 2 or 3 days, and he came home yesterday and found the door kicked in and she laying in the bed.
Okay, all right, I'm just kind of stop you there.
Okay.
And so you will be able to help your son, is that correct?
Yes, ma'am, always.
Okay, all right. And you're not in fear of him?
Who, my son?
Mm-hmm.
No, never.
Okay. Do you know him to be a violent person?
No, ma'am. This situation, ma'am, no, he's not. No, this situation, he's not doing anything.
Okay.
If he was, you know, I let him know. If he doing wrong, I will let him know.
Gotcha. Okay. All right. Thank you for your testimony.
Yes, ma'am.
All right. And so on this first case, what I'll do, everyone, is to grant a $1,500 surety bond.
What's that?
$1,500 good bond, surety bond. And then we'll do the other two cases. But I'm going to order no further contact with the victim, Adriana Nala. Can't pronounce it. Is it Nala Polino or Napolitano? All right. Also, I will not order stay away from the Huff Road. But if you get out on bond, Mr. Gearing, and you go back to that location and she's there, you should turn around and leave and not be there if she's there. Okay. So make sure that she's not residing there, and that you can be there only if she's not there. Okay. But I won't order a stay away at this time if you're telling me that she does not reside there.
She does not reside there. She doesn't have any key, mail, panty, piece of drawer, toothbrush, nothing. She's
Okay,
been away in my life.
okay, hold on. And I'm also gonna order no drugs, alcohol, or weapons if you are out on bond, okay?
Okay.
All right, now let's do your next case, which is 22 CR 000365G. And that's another count of battery family violence on the date of December 2nd, 2021. And again, Ms. Arnold, tell me about this case. Is it a different victim or the same victim?
Your Honor, yes, and I do apologize for not making that clear. All three cases are against the same victim that we're
Okay.
here for today.
I guess I should have asked that to begin with. Okay, all right, they're all with the same victim. Okay, tell me about this next case in December.
Yes, Your Honor. So the state is requesting a $4,000 surety bond on this case. No further contact with Adriana Napolitano, a stay away from the 903 Huff Road, apartment 1313 in Atlanta, a one-day anger awareness, and no drugs, alcohol, or weapon. Your Honor, this incident happened on December 2nd, 2021 at the Huff Road location. Ms. Napolitano advised that she and the defendant got into another silly argument again about him smoking in the apartment. However, this time the defendant got upset again and punched Ms. Napolitano in her mouth and her right breast, causing bruising to her breast. Your Honor, we've already went through the history. So again, we do believe that he will reoffend. And he has, at this point, Your Honor, we're here on 3 different offense dates against the same victim, going further to the notion that he will reoffend again and he will harm Ms. Napolitano again. So we are requesting that $4,000 surety bond with the conditions as stated. And Your Honor, I have heard what the defendant has said or what defense has said, Your Honor. I just want to make note, I know you've made your ruling in the other case, but on the police report, it does have Ms. Napolitano's address as that 903 Huff Road, Your Honor. I will concede that the state was not able to get in contact with her, so we could not verify, but it does have on the police report that they both reside at that address.
All right, I have to make sure that our victim is safe, especially with 3 incidents, October, December, and January. And so, Mr. Gearing, again, I'm inclined now to order a stay away and you go stay with your mother until things cool down, because I don't want you going back, if you do make bond, to this location and she's there and then you turn around and come right back to jail.
Ma'am, she doesn't live there, ma'am. She doesn't stay in Georgia at all. She's back and forth from New York, right, Spencerport to Georgia. She doesn't live here, ma'am.
And Your Honor, it's my understanding that if she is there, then the rent office is going to make sure she's not there because her name is not on the lease. She doesn't pay any bills there. And additionally, he has a roommate who stays there. And so it's not just his apartment, but it's his apartment as well as his roommate's apartment, which neither one includes her. And so she would come over, but her living situation is not there. And I think the no further contact resolves that, because as the court said, if she is there, then Mr. Gearing knows that he can't take matters into his own hand and try to remove her, but he would have to leave and then ask the rent office to remove her from the property. But
probably he would have to, maybe, I don't know if the rent office would do to call the police, and I guess he could show them, if he were to get out on bond, show them the bond order. I'm not usually inclined to say the victim should stay away from that location. But I guess if you're saying she's not on the lease, I just don't, want to set him up for failure or set her up for failure either way.
Your Honor, if I may.
Yes.
Traditionally, when this has come up in bond hearings, one of the things that the court will order is that there be a one-time escort to that location with law enforcement to check and see if the victim has vacated the premises. If she has vacated, then he can then take up residence. If she is not vacated, then he cannot. And that
Thank you.
tends to resolve this.
Wonderful. Okay, thank you. And that's what we'll do. Ms. Middlebrooks will add that to each of these bonds.
And Your Honor,
That-
is that him not being able to take up residence until she's removed? Because we just don't want it to be him not able to take up residence indefinitely and not able to return to his own apartment. If
But
it's
what I'm-
until she removed, then, then she has, the rent office has an opportunity to remove her, and then he can go back into his apartment.
That is correct. I mean, he needs to, make sure that if he's saying she doesn't reside there, she's not on a lease and should not be residing there, then that is fine. And he can take up residence as long as she's not at that location and not there. I guess if the police were to be called, or the rent office to go there, if she has items there, then they need to be removed so that she's not residing there. Especially if she's not on the lease. Like you said, I'm sure the rent office would, ask her to leave. But I do
And
know
that's all. We just wanted to make sure that we didn't interfere with the rent office currently processing her out of that apartment if she is there, because they have the lease. They know who's on the lease. They'll know if she's in the apartment, and they'll know that she's not supposed to be there if she's not on the lease. And so if that process, from my understanding, is already being done with the roommate, if she is there or if she does come there. And so we just want to make sure that, he can't go if she's there, but if she is there, once she's removed, that he can return to his own residence.
That is correct. I cannot order much else than the fact that if she's there, he shouldn't be there until she's removed and does not reside there, whether it's temporarily or permanently. And so that is exactly what I'm saying. So if he returns and gets out on bond tomorrow, the next day, and when he gets there, she's there, he needs to turn around, leave, go to the rent office, take his bond order, or call the police with his bond order that she is not supposed to be residing there. And if she is there, he cannot reside there until she is removed from that property.
Understood, Your Honor.
And I hope I didn't say that too circular, but I think I'm saying the same thing that Ms. Falk is saying. But, I can't order somebody to remove her because I don't know, we don't have the lease in hand. And this is not a dispossessory, this is not a, so I can't order that to happen. He would have to go through the proper channels to do a dispossessory case.
And Your Honor, that's what I was
Your
about
Honor.
to say.
And we're not asking for her, just to be clear, we're not asking for the court to remove her or to order that she stays away from the property, just what the court just already stated.
Okay, and that's what I was making sure. Yes, Ms. Falk? Oh, I didn't know if you.
Nothing further from me, Your Honor.
Okay.
Just was reiterating what the court just said, which is, quite frankly, if she's taken civil possession, whether she's on the lease or not, there's
Yeah.
going to have to be a dispossessory warrant filed and proper procedures would have to occur.
Correct. And that's what I'm afraid of. I mean, we don't know. We don't have lease in hand. She may be on it and he may not be telling me the truth. And, I don't always get a full factual information sometimes at these bond hearings, and people will tell me one thing and, later it's something different. So I can only order that the two of them should not be around each other because he is to have no further contact with her at all under any circumstances, because then that puts him in violation. So he has to protect himself in the interim as well. And the best I can do is to order that there be no contact with him, and he cannot reside at Huff Road if she is there or should not be there until she has vacated the premises, whether temporarily or permanently. All right, is that clear, Mr. Gearing?
Yes, ma'am.
All right, in your second case, I'm going to order a $3,000 surety bond. In your second case. And no drugs, alcohol, or weapons, same conditions, no further contact with this victim. And and you're not to be at the 903 Huff Road unless she is not at that residence. And I'm concerned now, I'm going to your third case. So let's see what we have on this third case. And Ms. Arnold, tell me about this third case, January 26th, yesterday.
Yes, Your Honor. So the state is requesting a $5,000 surety bond for battery family violence. In this case, we're asking no further contact with Adriana Napolitano, a stay away from the 903 Huff Road, apartment 1313 in Atlanta, one-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident happened just yesterday at the Huff Road location. Ms. Adriana Napolitano advised officers that the defendant slung her to the ground and then began punching and dragging her, Your Honor, causing multiple bruises on her arms, knees, and her legs. Again, we do believe the defendant will reoffend based on the fact that we're here on these three cases, different incident dates with the same victim, Your Honor, and based upon his prior history. So for these reasons, we are requesting the $5,000 surety with the conditions as stated. Thank you.
All right. And again, Mr. Gearing, I'm very concerned of someone who states does not live with you, but the police continue to be called to that Huff Road location with domestic violence incidents. So something is not adding up for me. And I'm not for sure what's going on, but it does not sound well as far as you continuing to catch cases with her being there, or she's not supposed to be there, taking other measures, not violence, to have her not at that location. So you need to govern yourself accordingly. So on this,
warrants.
I'm sorry?
I was unaware of the other two warrants until yesterday when the officer told me. I never knew about the other two warrants.
Okay. Well, they're there, and obviously there's police reports and they were called. Maybe they were not able to find you.
Mr. Guerin, you don't want to talk during your hearing.
Okay, remember your right to remain silent. These comments can be used against you. The state is here listening. All right, so on your last case, the state was asking for a $5,000 surety bond.
Your Honor, if I may, very briefly respond to the last case.
Oh, I'm sorry, Ms. St. Flex. I didn't mean to leave you out. I apologize. Go ahead. Yes, go ahead.
It's my understanding that Mr. Gearing was walking into his apartment with his new girlfriend when the alleged victim came into the property, and there was confrontation in which the police was called. And so for this case, it's my understanding that Mr. Gearing did not contact the alleged victim, but she sought him out and went to his place of residence. We are asking for this bond to be a $1,500 good bond. With the other two cases, Your Honor, then that would make his total bond $5,000. As I stated before, he was working before he was arrested, and it's our hope that if he can afford his bond and get out, he can return to work. And so we would just ask that of the court.
And he was working, did you tell me?
Yes, Your Honor, I said exclusive game ATL as a sales associate.
Sales associate, okay. You know how long you've been working there?
He said for over 6 months, Your Honor.
And tell me again, Mr. Gearing is how old?
Mr. Gearing, how old are you?
Oh, I'm 27.
All right, on the third case, I'm going to give a $2,500 surety bond on this case because I'm still concerned. And the same conditions, no further contact with Adriana Napolitano, and only be at the Huff Road if she's not there. So 1,500, 3,000, and then 2,500. Those will be the three bonds. All right. And those are your cases, Mr. Gearing. Good luck to you.
Thank you, Your Honor. May I be excused?
Yes, and those cases, if you don't make bond, they will be reset till February the 10th.
Next, I need you to be quiet. Next is position 13.
Okay. Rolando Kennedy.
Yes.
How you doing? How you doing?
All right, this is 22 CR 0000371A. One count of failure to use a crosswalk and the second count of obstruction of a law enforcement officer. Offense date January 26, 2022. All right, Mr. Long, I'm sorry, pretrial.
It's 8th arrest, 2019 trespass, 2018 FTA for a phrase. 2017 cruelty in the first, battery, family violence, trespass, obstruction and ad stopping arrest. 2017 battery, family violence, cruelty in the third. Was a bind over at East Point. 2015 FTA for a fray. 2014 simple battery. 2012 burglary, first offender.
Okay. All right, Mr. Long.
Thank you, Your Honor. The state's recommendation for the failure to use crosswalk will be a $500 surety, and for the obstruction, a $1,000 surety for a total surety of $1,500. No drugs, alcohol, or weapons. In this case, the defendant was seen crossing Lennox Road and Peachtree Road, not using the crosswalk at the light. He then obstructed Officer Caldwell, Fulton County Sheriff's Office, when he was trying to get his name and ask him questions. And he did so by fleeing on foot and having the officers chase after him. The state's made this recommendation based on his criminal history as stated by pretrial with 2 FTAs. I would also argue he's a flight risk because he tried to flee in this case as well. And we did think that he could potentially be a risk for reoffending. I saw an Odyssey what appeared to be an open failure to use crosswalk from January of 2018. And Odyssey appeared to also show an open 2017 case, which was magistrate pre-file for the simple battery cruelty to children in the 3rd degree. So for those reasons, we're asking for the surety bond as stated.
All right, Ms. Kim.
Yes, Your Honor. Mr. Rolando Kennedy is 28 years old. He was born and raised here in Georgia. He has lived here all his life, and he lives with his mother. When I spoke with his mother, I was able to find out that he actually receives Social Security check of $800, $40 per month. That's all he gets. And the reason that he gets those checks is because he has autism. He had that for all his life, entire life. Indeed, he needs extra help dealing with all these issues in his life skills. So having a high bond is really not the best way to approach this case. When I first saw the incident, I was kind of surprised by the fact that he was arrested for basically jaywalking a pedestrian in roadway. The warrant states that he, Mr. Kennedy, did not even yield to the right of the vehicle. I was kind of like wondering about what about the right of people, which includes Mr. Kennedy. Mr. Kennedy's safety was not a concern. It was more about the damage to the property that was more concerned. And the reason that he was fleeing in fits was because he was scared. And autism is basically the disease that has the symptoms that includes difficulty with communication, difficulty with social interactions, and he has obsessive interests and repetitive behaviors. Maybe that's why he has so many past charges. He doesn't really understand what was going on. When I was asking him, he didn't even remember actually he had those arrests. Probably he does not have the knowingly and willfully intention of mind in his brain right now. When the second arrest actually stated that accused Mr. Kennedy did not offer and did not do any violence to the person of said officer. Officer was not harmed. He was not hurt. He was probably just annoyed by the fact that Mr. Autism, the person with autism, walked away out of fear. And I think that having actually arrest is a little bit cruel punishment to people with such a what he needs is more tender heart and understanding. And when and also I was researching Odyssey, and it was stating that 2014 case was actually against Rolanda with A, not with Rolando with O. So it could be a totally different person with the same similar name. So it could not be himself. And yet we don't know exactly what happened in the past. Regardless of what happened in the past, at this particular incident, nobody was harmed, and his autism should be considered. And I really want the court to have a benefit of doubt for his condition, and also give him signature bond, because $840 a month is all he gets. And whatever the Mr. Long the state is asking for is way too high. Thank you, Your Honor.
Mhm. I'm going to order a 2,500 signature bond through pretrial per judge. And no drugs, alcohol, or weapons while on bond. And no further violent contact with Officer Caldwell. And he's a sheriff's deputy. Did I hear that correctly?
Fulton County Sheriff's Office.
Yeah, no further violent contact with him. And
Judge, is that, how is that broken down on the 2 counts?
on the 500 on the failure of the crosswalk, and then 2,000 on the obstruction. So that's the 2,500.
Your Honor, he never had any violent contact with an officer, so just no further contact should be enough, Your Honor.
Okay, and that's fine. I'll change it to no further contact.
Thank you, Your Honor.
Mhm. All right, good luck with you, Mr. Kennedy, but you're going to be monitored by pretrial. So you're going to have to report into them and cooperate so that your bond is not revoked. Okay?
You got signature bond. Position 14.
Mhm.
Position 14.
Okay. Is that Manafi or Manafi?
Manofi.
Manafi, okay. All right, 22 CR 000378C, charged with 1 count of simple battery family violence. The offense date is January 26, 2002. Pretrial, do you have anything?
Yeah, first arrest. That's what my file says.
Okay. All right. Mr. Long?
Yes, Your Honor. In this case, the state is recommending a $1,500 surety for the simple battery family violence count. At this point, we are asking for no further contact with the minor victim, YM. and stay away from their joint residence of 430 Briars Bend, Alpharetta. We would inquire of defense if there's another place for the child or defendant that they're aware of to stay while the case is pending. 1 day anger awareness, no drugs, alcohol, or weapons. In this case, which actually occurred at a third party's residence that is not a party to the case, law enforcement were called for a domestic dispute. The defendant met with law enforcement and said that he had located his daughter at the address of 2740 Bethany Bend in Milton. And he found her there after knocking on the door, and the owner of that residence opened the door and he found his daughter inside. When he found her inside, he slapped her on the head with an open hand, according to the defendant. Then law enforcement spoke with the minor victim, who stated that when the defendant found her, this is her father, he was mad at her and repeatedly punched her with a closed fist on multiple body parts and then kicked her. There were other witnesses, but they were unnamed in the warrant, and at this point I don't have further information about those witnesses. Victim witness advocate from our office was unable to make contact with the minor victim prior to today's hearing, but we're asking for the surety bond and the no further contact and the stay away, primarily because of the risk of victim intimidation. This is his daughter, and we believe that there would be a high risk that she would conform to whatever wishes her father had regarding the case, especially given her vulnerable age of 17. So for those reasons, we're asking for the $1,500 surety. Thank you.
All right, Ms. Kim?
Yes, thank you, Your Honor. Mr. Sam Manafi is U.S. citizen. He's a senior citizen. He is old, 61 years old, and this is his second marriage. And the daughter is actually his stepdaughter. He does not oppose to stay away from her and never contact her. However, it is very important that it becomes a signature bond because of the fact that he never had any criminal history. His past is very clean, and as the pretrial service recommended, he is the best candidate. He meets criteria for unsecured judicial release, so he is qualified for signature bond. He came to U.S. in 1985, and he became U.S. citizen. He is an owner of a small business with the employees. From 1998, he has managed to have a successful business. He sets up the network for the computers. He has a master's degree in computer science. He's professional, very involved in the community. And he's not a threat of, he is not going to have any flight risk. He's very, he has a strong ties into the Atlanta, Georgia. And again, I just wanted to emphasize that there was no single criminal history, not open case pending, no probation, no felony, no failure to appear. This is the first incident. So I ask for a signature bond, Your Honor.
Okay. And so the defendant resides at the Briar Bend Road in Alpharetta with the victim?
No, Your Honor. That's his home that is actually paid off. He owns it in his name, and she lives a different place with where the incident happened.
Oh, okay.
That's what I understood, but we have to verify further.
Okay. So she does not, so there should not necessarily be a stay away from the Briar Road?
Correct,
So,
Your Honor.
Your Honor, the warrant information that I saw had the 430 Briars Bend as the victim's address. So that was why we asked for the stay away.
Can your client answer that truthfully for me?
Would you please?
Yes, Your Honor. Yes, she does live in that house Your Honor,
Yes?
she does sneaked out of the house in 3 occasions to that other residence. And,
Okay, just answer simply. I don't want you to say too much more, but at this Briar's Bend, the victim and yourself reside there?
that is correct.
So you would have somewhere else to go reside?
I do work there as
Huh?
I do conduct my business.
Oh, you run your business out of that location?
That is correct. And it's, I'm the only paid off the house before. I mean, I paid it off.
Does anyone else live at that location with you
My
and your
wife.
stepdaughter? Your
Yes,
wife?
my wife and I'm my biological daughter, that I support them. They live in that house and they depend on me to work in that house and then to provide them for food and also my business. And many other people.
How old is your biological daughter?
16 years old.
Oh, 16, and then the victim is 17.
That is correct.
Well, I have to make sure that my victim is going to be safe and that we're not going to have any more violence.
You can be sure about that.
If you were allowed to go back to that home. And so here's what I'm going to do. I'm going to give you a $2,500 signature bond through pretrial. I am going to order that there be no further violent contact with YM. He's a minor. You'll have to find some other methods, but if you have any more incidents, you'll be arrested again. I'm not going to order a stay away from 430 Briar's Bend. But again, you would have no further violent contact with the victim in this case. And since you're running your business from there, I will allow you to go back there as long as you do not have any more incidents. I'm going to order you to take the 1-day anger awareness course through pretrial. And I'm going to order no drugs, alcohol, or weapons while on bond, unless those drugs are prescription drugs ordered by a doctor. All right. So that is what I will do. You'll have to be monitored by pretrial while you're out on bond.
Thank you, Your Honor. It's very generous.
All right, you're welcome.
Position 16. I'll let him pronounce the name, Judge.
All right. I don't want to mispronounce your last name. Olawatasin. Okay, case number 22 CR 00379C. Charged with 1 count of expired or no license on person, 2nd count of driving or speeding, 3rd count of driving improper passing in a no passing zone, 4th charge of giving false name, address, or birth date to law enforcement officer, 5th charge of obstruction of a law enforcement officer, and the 6th charge of no insurance. All right, the defense date is January 26, 2022. Do you have anything pre-trial?
It's his 3rd arrest. He was arrested in 2018. Driving without a valid license, DUI, hit and run. The driving without a valid license was a conviction. Hit and run and DUI was dismissed. 2018, he was arrested by ICE. Deportable alien.
Okay. All right, Ms. Duncan.
Yes, Your Honor, in addition to what pretrial has stated, this defendant, according to Odyssey and the GCIC, is confirmed as warranted and outstanding in Lawrenceville for a misdemeanor warrant with the warrant number W852336982. This incident occurred yesterday. An officer was monitoring traffic in Carter, was monitoring traffic on Pine Grove Road and Tangle Tree Road in Roswell. And this officer observed a car going at a high rate of speed. He visually believed it to be about 60 miles per hour. And that was confirmed via the radar that the officer had at the time. The posted speed limit in that area was 35 miles per hour. Upon effectuating a traffic stop, because the vehicle was also seen passing another vehicle going eastbound across the double line. Upon stopping that vehicle, the police officer asked the defendant for his license, and he did not have one. He gave a name and date of birth. The name and date of birth that was given was Remy Bankole, that's Remibankole, and the date of birth that was given was March 23rd, 1961. GCIC returned a valid license for that person. However, the photo for that person did not match the defendant in this case. When questioned about the identity, the defendant became increasingly nervous and was shaking. Police officers at the time called the number listed for that person. That name was given, and that person answered the phone and stated that they were indeed that person, and they did not know who they had pulled over, and that person was using their name and birth date. So the officer sent the person on the phone the picture of the driver, and the person on the phone identified the driver as his in-law, but did not give any additional information. The person on the phone provided the name of Tosin Adejoro, which in this case, for the person that he thought it was on the phone. However, the birth date and the birth date given was a different birth date. It was March 25th, 1982. Also, Your Honor, just to make sure I'm covering all of them. Yes. So when approached about the differences in identity for this case, the defendant was told to stay in the vehicle at the time, but when the officer went back to his car to confirm the information, the defendant got out of the car and made chase. He was chased for a while, and then when he was apprehended, it was determined that he did not have insurance. It is for these reasons that the state is requesting a $6,000 surety bond, $1,000 per count, no alcohol, drugs, or weapons, and no driving.
All right. Is this your case, Ms. Gant?
Yes, it is, Your Honor. Mr. Adejoro Oluwatosin is 39 years old. He was born in Lagos. However, he has been in the Atlanta area for the past 5 years. He has family here, including a sister and a mother. He has a 6-year-old child in Nigeria. However, he does have a fiance here. He has been engaged to Ms. Bobin for the past 2 years. He completed high school, and he also has a bachelor's in psychology and philosophy. At this time, Your Honor, he is engaged in international business. He is a principal partner in Network Energy. However, that business has not been as profitable as he had hoped. Therefore, he has no more than $3,000 to, let me back up, $300 if he's able to have these charges through a bonding company. However, Your Honor, I am requesting a signature bond on Mr. Oluwatosin's behalf, primarily because these are non-violent driving offenses. He did not offer any violence to the officers. He states that a passenger in the car was having convulsions and he was quite afraid. Based upon, I guess, that the condition of that person. There were no accidents. There wasn't an accident that arose from this event. Furthermore, Your Honor, I would just ask that you grant a signature bond in grant a signature bond on Mr. Olawatu's behalf so that he will be in a better position to deal with the Gwinnett hold, Your Honor. Thank you.
Your Honor, if I may,
Uh-huh.
the documents presented to the state and the warrant do not mention any reference to a passenger at the time of this incident, and this defendant's identity was verified by alias and through GCIC. Nothing further.
All right. Did you, and I think you may have told me, did you tell me what the speeding was?
Yes, he was going 60 miles per hour in a 35-mile-per-hour zone. It was verified visually and by radar at the time of incident.
All right, I'm going to grant a $6,000 surety bond through the jail. $1,000 on each charge. I'm sorry, signature bond. $6,000 signature bond through the jail. I said it wrong. $1,000 on each of the charges. And you are not to drive, Mr. Olawatosin, because it seems like you don't have a license. So you're not to drive unless you have a valid license issued by DDS. If you had one, you would be limited to only drive for medical care, for work, or for seeing your attorney. But if you don't even get that from DDS for limited driving or not at all, then you are not to be driving. You will have to get ride shares, Ubers, and I guess I'll let you take the MARTA bus. But I want to be clear with you, you should not be caught driving again for a while until you are able to get your valid driver's license back. Do you understand that? I'm sorry?
Yes, Your Honor.
Okay. So you have a signature bond through the jail. And no drugs, alcohol, or weapons while on bond. And that should conclude the matter. Anything else I need to take up, Ms. Duncan?
Nothing further, Your Honor.
All right. All right, that concludes your case.
Thank you, Your Honor.
Thank you.
Position 17, Randall. What you say?
All right, this is case number 22 CR 000373E. Mr. Randall, is it Laval?
Laval.
Okay, you're charged at one count of battery family violence, and the offense date is January 26, 2022. Do you have anything pretrial?
7 total, 2019 marijuana possession, 2016 probation violation for marijuana, another 2016 probation violation trespass. Came off a 2015 trespass conviction and a 2015 disorderly conduct dismissed.
Okay. All right. Ms. Duncan?
Your Honor, this incident occurred yesterday at around 5 p.m. A Miss Ashley Stroud was on FaceTime with her sister, Quatisha Stroud, the victim in this case. We have Quatisha as Quatesha Stroud as Stroud. Miss Ashley was on the phone with her sister, Quatisha, and Miss Ashley saw the defendant, her sister's boyfriend, punch Quatisha in the face before the call had dropped. Miss Ashley attempted to call her sister back, however, she could not reach her sister. So then she called 911 and she asked the officers to do a welfare check on her sister after witnessing her being punched in the face. So police went to the location and they encountered Miss Quatisha Stroud, who was already at the door. She was described as having red eyes and a swollen bottom lip. Miss Stroud told police at that time that her boyfriend, the defendant in this case, with whom she shares a 1-year-old child, had punched her in the face and slapped her. Ms. Stroud said that this altercation started over a petty argument involving a family dispute. She told the police at that time that she was tired of putting up with the constant abuse and that she wants to press charges. Our victim advocate did speak to Ms. Stroud in this case, and she stated to our victim advocate that she wants him to come back home and that she's no longer wants to press charges and has denied any previous abuse. She stated that she would be on Zoom. While we understand and respect the victim's wishes in this case, we are concerned because likely this incident was captured on body-worn camera, and according to the warrants, she did indicate that she was tired of him constantly putting his hands on her, which to us indicates a cycle of unreported abuse, and that's why she's currently pressing charges. Even though the defense may argue that these charges were not reported, this information is relevant due to the fact of the intimidation of witness here and the risk of reoffense. We would not expect her to have called the police in this instance because she hasn't before. And in fact, Your Honor, her sister is the one who called the police. So we're just very concerned about her safety, and given the defendant's history and the information from the warrants, the state is requesting a $4,500 surety bond, a stay away from the incident location, no further contact with the victim in this case, third-party child contact, no alcohol, drugs, or weapons, and one-day anger awareness.
Okay, Ms. Gant.
All right, thank you, Your Honor. Mr. Laval Randall is 23 years old. He was born in Atlanta. He has been here all of his life, therefore he has community ties. At this time, we are opposed to the stay away order. Your Honor, Mr. Randall shares that residence with Ms. Stroud, and we heard from the state that she wants him home. They share a 1-year-old child together. He's very active. He's actively involved in the care of that child. In fact, he has informed me that Ms. Stroud is a stay-at-home mom. Therefore, she relies on him to provide for both of their financial needs. He has completed high school. Let me back up. He completed the 12th grade. However, he went on to attain, he stopped in the 12th grade, but he went on to later obtain a GED. He is currently employed at staffing services, and he loads items at Hartsfield Atlanta Airport. I am asking the court for a signature bond on Mr. Randall's behalf. We did not hear about any convictions whatsoever regarding violence. And furthermore, he denies the allegations. He has a competing version. He does acknowledge that there was an argument that he did not start. Furthermore, he states that Ms. Stroud bit her lip when she was trying to retrieve her phone. At this time, Your Honor, I would just like to address the state's contention that there are things that are likely captured on body camera. However, I would ask this court to not rely on things that are likely captured. And furthermore, we have not had the occasion to view any video surveillance of this incident. So for these reasons, Your Honor, I'm requesting a signature bond on Mr. Randall's behalf. Again, we are opposed to the stay away and would ask instead, Your Honor, for a no violent contact order. And if Your Honor determines that he is ineligible for a signature bond, then a bond of no more than $100 due to his obligations in terms of keeping his family together. He does not have much to contribute toward bond. Thank you.
Okay.
Your Honor, if I may,
Yes.
this incident occurred a little over 24 hours ago. And even though it's likely that the incident is on body-worn camera, it is also documented in the warrants, specifically that the victim in this case stated that she was tired of putting up with the abuse, so now she wants to press charges, insinuating a continued pattern of violence in this case.
And if, Your Honor, if I may respond.
Yes, you may, Ms. Gant.
With regard to tired of putting up with abuse. There is one charge here today. I mean, there's an allegation for an incident that occurred yesterday. So I would ask that you not consider, and furthermore, it's speculative, because there are no accusations, there are no prior arrests regarding any particular, dealings between these two as relate to violence. My client does not have any history whatsoever of violence. They share a child together, and therefore they've been in a relationship for a period of time without any involvement of the police.
Okay. All right, I am making sure, and I think did I see someone on
Yes.
this case?
She's on there.
Yes, I am present.
Okay, do you want to address the court, Ms. Strauss?
Yes, but my camera is not acting right, so I won't be able to be seen. If I could still speak, that would be fine with me.
I cannot allow that because we don't know who you are and don't have your face to be seen. Unfortunately, we have to see your face.
Okay.
So you don't have a way to see the button there on.
No, it's not. My camera, my phone is actually messed up. I'm on my phone, and my camera, I can't even turn my camera on.
Okay, well, I'm sorry, we can't allow it without that.
Okay, that's fine.
Okay, and I appreciate your time. And so the victim in this case, is it Ms. Stroud or Miss Ashley?
It's Quatisha Stroud. Ashley is her sister who called the police after witnessing her sister being punched in the face.
And again, Your Honor, I apologize for interrupting. That's an allegation.
All right, I'm going to order a signature bond, $3,500 through pretrial. Signature bond, $3,500 through pretrial, one-day anger awareness class. No further contact with the victim, Quatisha Stroud. Is there a stay away address?
Yes, Your Honor.
All right, what is that?
The stay away address is, it's 1150 Astor Avenue, Southwest. That was the incident.
ASTOR?
Yes.
Okay. And is there a need for the third party?
Yes, Your Honor, along with a one-time law enforcement escort.
Okay, so there should be third party to assist with the exchange of children for visitation. And one-time escort with law enforcement. If Mr. Randall, you need to go back to that location, you have to have a police escort, law enforcement. You cannot go back there alone.
Yes, ma'am.
Okay. No drugs, alcohol, or weapons while you're on bond. And if you want to see your children, you must have a third party to do that and facilitate it and help you with the exchange. And is there anything else I need to take up?
Nothing from the defense.
Okay.
I apologize for speaking over you, Ms. Duncan.
No problem. All right. That should conclude this case.
Position 21, Wilson.
Okay. Are you Kyler Wilson?
Yes, ma'am.
All right, this is case number 22 CR 000377J. You're charged with one count of possession of marijuana less than an ounce. driving, window tint violation, and carrying a concealed weapon without a license. Those are the three charges, all with the offense date of 1/26/2022. Pre-trial, do you have anything?
First arrest.
Okay.
Your Honor, if I may, that carrying a concealed weapons charge has been NOD'd and that documentation has been sent to the appropriate parties as well.
Okay, so we're down to just possession of marijuana less than an ounce and driving, window tint violation. Those are the only two charges that remain.
Yes, Your Honor.
Okay, and go
This-
ahead. Go ahead, Ms. Duncan.
This instance occurred yesterday. The accused was engaged in a traffic stop by officers and at the address of 955 Juniper Street, Atlanta, Georgia. That's JUNIPER. While engaged in that traffic stop, officers noticed that the tint on his vehicle at the time was below the legal limit of 32%. It was confirmed that the tint on the vehicle at the time was about 10%. At the time of the stop, officers also smelled a strong odor of marijuana coming from the vehicle. They asked the defendant if he had marijuana, and the defendant admitted to having some. Due to the fact that this is the defendant's first offense, the state is recommending a bond amount of $3,000 signature. That's 1.5 thousand per charge, and no alcohol, drugs, or weapons.
All right, Ms. Gant.
The defense consents if she stated 3,000 signature.
Yes.
Thank you. We consent to all, the bond and all conditions and the condition.
All right, and that is what we will do. I will order a $3,000 signature bond through the jail. And no drugs, alcohol, or weapons while you're on bond, Mr. Wilson. And need to be careful, and I hope that once you get out, you get the tint removed from that vehicle so you don't get pulled over again. And again, unless you have a prescription for any drugs, no marijuana, no drugs, no alcohol, and obviously no weapons with you while that are unregistered or unlicensed while you're on bond, but you will be on a $3,000 signature bond. Okay?
Is that through the jail?
Through the jail. All right. That concludes your case.
Okay, go sit over there. Judge, you have South Annex there on.
All right, on that number, is that case number 19?
Judge, we have Miss Wallace Shields.
He's 18, Judge. Can
18.
courtroom 2 be dismissed, Judge?
Sorry?
Can courtroom 2 be dismissed?
Yes, you may. Thank you so much.
Okay, thank you. Y'all have a good one.
You too. Who do you have at the South Annex?
This is Miss Wallace Shields, Brianna Wallace Shields.
All right, position 18. This is case number 22 CR 000374J. Obstruction of a law enforcement officer. Offense date 1/26/2022. Pre-trial, what say you?
24 total.
Give me the last few convictions.
She's on probation for robbery. She's on probation for robbery and giving false names. Case number 21 SC 177410.
Okay.
The last arrest was in 2020 for the robbery. You said convictions?
Okay.
2019 PI, as you call it.
Okay.
Stuff by taking, trespass. You play a no-low to those.
Okay.
Got obstruction, trespass, simple battery, no-low from 2019 out of Clayton County. 2019 failure to appear. 2018 probation violation. She had a recent probation violation too. 2017 shoplifting conviction. 2017 probation violations.
All right, that's pretty good. All right, Miss Duncan.
Yes, Your Honor, in this case, in addition, I would just like to add that the GCIC indicated that this defendant is also on an outstanding warrant for failure to appear out of Lawrenceville, and she has a prior conviction for prior convictions for obstruction as well. In this case, the defendant is residentially challenged, and she was encountered by police officers, and in that instance, she was told to put her hands behind her back. And instead of doing so, this defendant began pulling away from officers and refusing to be detained, and continued smoking a crack pipe in front of officers. This defendant was pepper sprayed for refusing to be detained and continued to resist arrest. The state is particularly concerned in this case due to the previous conviction for obstruction and failure to appear. We are concerned that she may be a flight risk. Due to her history and the facts in this case, the state is requesting a $3,000 surety bond. And this took place at 378 Boulevard Southeast. We're asking that the victim stay away from all MARTA and no further contact with the particular officer in this case, which was M. Ruker, and no alcohol, drugs, or weapons, and an ADET.
Give me the officer's last name or spell it for me.
Ruger or Rucker, R-O-O-K-E-R, first name M.
All right, Ms. Gant.
Your Honor, before I begin my presentation, I would just like to clarify, did the state ask for a stay away from MARTA?
Yeah.
I meant to say, my apologies, stay away from the incident location.
Okay, thank you. All right, thank you for the clarification. Thank you, Your Honor. Miss Brianna Shields Wallace is 25 years old. Yes, she is in fact residentially challenged. However, we are working with our social workers who connect her to services. She was born in New York. She has been in the Atlanta area for most of her adult life. Let's see here, completed the 11th grade. She has been unemployed for many years. However, she is not disabled. Therefore, she is unable to pay any bond at this time. For these reasons, I am requesting a signature bond on her behalf so that she may deal with that foreign count, the Gwinnett hold, a signature bond through the jail. And again, we are not opposed to a stay away from 378 Boulevard Southeast. Thank you.
And this location, 378 Boulevard Southeast, do we know what that is?
My understanding is that it's an apartment complex, but she does not live there.
Yes.
She hasn't hold in Gwinnett. Has she been working at all?
Unemployed since 2013, long-term.
How is she supporting herself? Is she getting any other benefits or something?
Not at this time, Your Honor. However, well, I'll just leave it at that. She is unemployed and not currently, well, has not been approved for disability benefits.
until you all are going to work with her, Ms. Gant, on the, with your social worker, social services.
Yes, Your Honor.
I am going to order the $3,000.
Your Honor,
Uh-huh.
I do apologize for interrupting. I just looked at my notes here. Your Honor, I would ask that you not grant the alcohol, drug and evaluation and treatment order. There's no way that she will be able to afford that, Your Honor.
Yeah, thought about that. Okay, I guess I'm concerned of continuing to hold her in and knowing that she needs to go to Gwinnett to deal with that. And I know but I want to know that she's going to get some services to assist her to not be a revolving door to come back into the system. Hopefully, that you all can work with her. I don't know, will you be able to get to her before she's transferred up to Gwinnett?
I was in touch with the social worker today, and we had tried to have her contact her prior to the hearing. But due to, I guess, the short period of time from which I completed the interview and court started, we weren't able to accomplish that. But she's on it, Your Honor. It's Nakasha Williams.
All right, I'm going to order a $3,000 signature bond through the jail. And no drugs, alcohol, or weapons while you're out on bond, Ms. Shields Wallace, unless it's something prescribed for you. You're going to work with the social services with the public defender's office to assist you with some of your needs. Okay, I want you to work with them so they can help you. And no drugs, alcohol, or weapons while you're out on bond unless it's something prescribed to you. And we're going to have you to stay away from the incident location 378 Boulevard Southeast. Also, there's going to be no further contact with the victim, Officer M. Ruker. And that's all I will order at this point. Good luck to you.
Thank you.
Okay.
Judge, quick question. Is that for all 3 charges?
I
That
only
was a
have
total-
one.
Only one.
On position 18, Shields will only have 1 obstruction.
Okay, thank
What you have,
you.
Ms. Middlebrooks? Yeah.
Yes.
Okay, just the 1 charge.
The other stuff are bench warrants.
Oh,
Okay, next I have my last case is going to be Tracy Thomas.
and is this the one that you need to speak with, Ms. Gant?
Yes, Your Honor.
Is there a number that she can call South Annex to speak with Ms. Gant? I mean, speak with Ms. Thomas?
Yes, either that or she can do a breakout, either or.
Your Honor, I'm unable to call the jail, so is it possible for South Annex to call me in the breakout?
No, it's either the breakout or call. I can call you.
Okay, please call me.
Okay.
Thank you.
So you're putting your number to her in the chat, or she has your number?
She should have it. Do you have my number? Do I need to put my number in the
Yes,
chat?
I got it. I got it, Ms. Gant.
Okay, thank you.
Good. Okay. All right, we'll give you a few moments as quickly as you can.
All right, thank you, Your Honor. I will be as brief as possible.
Okay, we'll be on recess for a few minutes.
Judge, how much longer we gonna be in recess? I need to go to the bathroom.
What? Go and go.
I am wrapping up the
Okay.
interview now. So
Okay.
I think you have time to go. I'm wrapping up now. Thank you for your.
Okay, so let him go. Come
Yes.
back, run and come back.
All right, Judge, we're ready.
Yes, ma'am, thank you. All right, this is case number 22 CR 00375G. Ms. Tracy Lynn Thomas, one count of simple battery, family violence, offense date 1/26/2022. Is pretrial back? He may not be back. So go ahead, Ms. Duncan.
Okay, Your Honor, this, according to my research, is the defendant's second arrest. She has a prior simple battery and cruelty to children in the first, which was in which she was given 5 years probation and 12 months probation in 2004. That was under first offender, sealed in 2017, and this is her second arrest. In this instance, Your Honor, the defendant and the minor MT were in an altercation, and the facts of this case are that the defendant pushed the minor MT and broke her cell phone. The defendant stated to the officers that she had approached her daughter, MT, about running away, and in approaching her, a physical altercation ensued. The daughter, MT, indicated that she did push back. However, and there's a concern in this case due to the fact that this defendant has a previous cruelty to children in the first, and which was before this victim was born. My apologies, but she has a history of having issues with children that are in her care or with whom she lives. So we're concerned about the safety of this defendant due to the violence that occurred in this instance. So we're requesting a $5,000 surety bond, no further contact with the victim, in this case, minor MT. However, the state would like to inquire with the court if the child has anywhere else to live. We do not have that information. And we would also request no alcohol, drugs, or weapons, one-day anger awareness, and to follow conditions set by Department of Children and Family Services if they are involved. Since this incident just occurred yesterday, we are unsure of that status, and this incident did take place at 849 Capitol View Avenue. So it's for those reasons stated that the state is requesting the bond and the conditions.
Okay. And how old is the victim? Do you know?
14.
14. And it's obviously not the same as the one in the prior case, correct?
No, that's a different, that was before she was born.
Okay, gotcha. I think you said that. All right, Ms. Gant.
All right, thank you, Your Honor. Miss Tracy Thomas is 44 years old. She was born in Atlanta and she has been in the Atlanta area for 20 years. She has community ties. In fact, she is the proud mother of 10 children, and she has, let's see, 5 children under the age of 18. She is the primary caretaker for her children, including MT. She is a high school graduate. She has been gainfully employed as a security guard at Southern Protections for the past 4 years. Your Honor, Miss Thomas is scheduled to start a new shift on Friday. Therefore, she needs to be released. And furthermore, her children are in the care of her sister. So she needs to get back to resume the care of her children. Regarding the allegations, she denies the allegations. And I would like to bring to the court's attention that minor MT was also detained. Ms. Thomas has informed me that there was an argument, but she did not start it. She was basically trying to intervene because minor MT was into it with another one of her siblings. And when Ms. Thomas tried to intervene to just basically resolve that situation, minor MT actually attacked Ms. Thomas. Ms. Thomas denies making any physical contact with her whatsoever. Ms. Thomas called the police. She also had, scratch that, Your Honor. Ms. Thomas states that minor MT slung her to the floor during this incident and was cursing at her. And also, Your Honor, she informed me that earlier that minor MT had kicked the door in. So therefore, it's clear on these facts here, Your Honor, that Ms. Thomas is not the primary aggressor. I am opposed to the stay away, Your Honor, at 849 Capitol View Avenue, as that is the, well, I'm sorry, Your Honor, the state did not ask for a stay away. I would ask for a no violent contact order. And Ms. Thomas, may you clarify whether or not MT has another residence?
They can't hear me. Yeah. Okay, yes, she does. She's there. Okay. She's over there now.
Okay.
They left the home
okay,
long
thank
time
you.
ago.
That's what we need to hear from you. Thank you so much. So again, I would ask for a no violent contact order and a signature bond, being that my client has not been arrested since 2003. She has paid her debt for that, and the state's allegation that she is not safe around children is baseless. And that concludes my argument. Thank you, Your Honor.
If I may, Your Honor?
Yes.
The record indicates that the victim in this case stated that the violence occurred due to her mother coming in her room and pushing her and breaking her phone. And in response to pushing, she pushed her back. And the facts also indicate that the victim was interviewed by, the defendant was interviewed by police officers and was told that she talked to her about running away, and the physical altercation came from the two of them, not a third party.
And Your Honor, we've offered our competing version. And there's something in there about a runaway, but what we are solid in our position that Ms. Thomas did not start this. And she did not have any physical contact with her daughter.
Okay. Well, I understand it's tough, and it's tough with teenagers these days. So, you know, I applaud you, Ms. Thomas, in trying to do the best you can. You have a lot of children, and you have a lot on your hands. So I'm going to grant you a signature bond, $5,000 signature bond, and through pretrial. So you'll have some monitoring to do with them. I'm going to order for you to take the one-day anger management course, okay?
Yes, ma'am.
You have to find a way. I know it's tough to deal with teenagers these days. And I'm not going to order stay away from your home.
Thank you.
But I think, you know, you definitely need that cooling off period. And if your daughter can go stay with your sister for a while so that you all can get it together and maybe find some counseling or something that you all can get in, and your daughter can understand her limits and boundaries as a child, and all those kind of things. Like I say, a $5,000 signature bond through pretrial, the one-day anger management, no drugs, alcohol, or weapons while you're on bond, unless it's something prescribed. And I'm going to say no further violent contact with MT.
Yes, ma'am.
And so, you know, once you get out, just be careful until you can take this class and get you all some counseling, some family counseling, and see what DFACS can offer if they're involved, or find some way so that you all can learn to coexist, because she needs you. But I know that it can be tough. So I wish you good luck with that, okay?
Thank you.
All right, you're welcome.
Thank you so much.
All right, you're welcome.
All right, Judge, we're completed here. Can I be excused?
Yes, ma'am. Have a good evening. Thank you so much.
Thank you. You do the
All right.
same.
Take care.
All right, thanks.
Judge,
Yes, sir.
we done. I don't need to go over the calendar, so I'll go ahead and cut out.
I thought you were going to stay with us. So you always try to leave us.
Well, I actually get off at 4:30, so I've done my time today.
I'll have to see who can buy you lunch for being working overtime.
And it's 6 o'clock, so I'll see you next time.
Yes, take care. Thank you so much for your help. Okay. That is my timekeeper who always reminds me what time it is. Okay.
Position number 1 is a $7,500 good bond, reset February 10th, SAP. Position number 2 is a $4,000 good bond, reset February 10th, SAP. Position number 3 is a $3,500 good bond, reset February 10th, SAP. Position number 4 is a $3,000 good bond, reset February 10th, SAP. Position number 5, 6, and 7 are all reset SAP February 10th. Position 5 is a $1,500 good bond. Position 6 is a $3,000 good bond. And position 7 is a $2,500 good bond. Position 8 is a $1,000 good bond, reset SAP February 10th. Position 9 is a $10,000 good bond, reset SAP February 10th. Position 10 is a $3,000 good bond, reset SAP February 10th. Position number 11 is reset medical to tomorrow's SCA calendar. Position 12 is a $5,000 good bond, reset SAP February 10th. Position 13 is a $2,500 sign-on bond through pretrial, reset further notice. Position 14 is a $2,500 sign-on bond through pretrial, reset further notice. Position 15 is a $10,000 good bond, reset SAP February 10th. Position 16 is a $6,000 sign-on bond through the jail, reset further notice. Position 17 is a $3,500 sign-on bond through pretrial, reset further notice. Position 18 is a $3,000 sign-on bond through the jail, reset further notice. Position 19 is a $5,000 sign-on bond through pretrial, reset further notice. Position 20 is a $2,500 good bond, reset SAP February 10th. Position 21 is a $3,000 sign-on bond through the jail, reset further notice.
Any questions? Any corrections?
Number 20, what is the name for number 20, position 20?
22. And you said, what is the name? Oh,
Yes.
Shamaya Watley or Shamaya Watley? Is that who you had as 20?
Yes.
Okay, that bond amount is the surety. Okay, thank you.
Yes. All right, you're welcome. All right, thank
Your
you
Honor,
all.
if I may,
Yes.
could you clarify the conditions for position 19?
Conditions, 1-day anger management class, or do you want to read it? Ms. Middlebrooks, correct me if I'm wrong.
1-day anger awareness class, no further violent contact with the minor child MT, no drugs, alcohol, or weapons.
Thank you.
Right, I didn't do the stay away. When I mentioned DFACS and counseling and things of that nature, I didn't order it, but hopefully she will, take my suggestion on it.
Okay.
Because I'm sure it's tough. Anything else? And thank you as usual, Ms. Falk, for helping me.
No problem at all, Your Honor. Thank you so
Those
much.
Interesting cases, 5:55. I was trying to get you out before 6.
Your Honor, I think we all knew this calendar was going to be a beast. So,
well, I didn't. I did SAP today, so I've been sitting here for a long time. But I did not. I thought they were treating me fair, but obviously not. As long as I don't have Monday. I used to say Mondays, but now I don't know. Whatever day it is, it's going to be a long day. But I appreciate you all for hanging in there. All right. See you all next time.
Have a good evening.
Thank you, Your Honor.
Bye-bye. Bye-bye.